CBS News legal analyst Jack Ford, good morning.
Good to see you, Harry.
This is very touchy stuff for him to say, or at least as long as we're reporting that he is saying to authorities there was some sort of sexual contact. There was not sexual assault. How do you parcel out all of this information?
Well, you know, if I'm representing him, I had said to him from the very beginning, all right, I got to know what happened here. If there was some sort of relationship, but you're saying it was entirely consensual and appropriate, fine. Let's get out and say that. Because right now, all of this is floating around, and there are no answers to the questions. So I think right now, but you've changed the dimensions of this discussion right now. Because you're not saying, it never happened, I wasn't near her. You're saying, here's what happened.
Something
from my perspective,
happened.
There was something there. I'm saying it wasn't criminal. She's saying, oh, no, it was much more than what you're talking about here.
So much of this ends up being about the credibility of the person who has been allegedly assaulted. She went straight to the authorities, right? They presumably have they will get some sort of DNA evidence.
And here's what the important thing, going back to my days as a prosecutor, as an investigator, you look for some sort of index of reliability here. And traditionally what happens is if you have a victim who goes right to the police and says, this is what happened to me, this is terrible, I didn't agree to this, this was a crime. You know, investigators say that helps them. Prosecutor says this helps me. And most importantly, if this ever goes to trial, we don't know if it will. We don't know what happened here.
This is very early.
Exactly. But if it ever goes to trial, that's important to jurors, because jurors will say to themselves, if something happened to me, if I was a victim, first thing I'm going to do is go to the police. So it can be very helpful there.
We may be putting the cart before the horse, but assume they have some sort of DNA evidence that the prosecutors do. How do they compel Ben Roethlisberger to provide a DNA sample?
Well, interestingly, the way the law has evolved, that's not a problem anymore. You know, you're talking about you can't be compelled to incriminate yourself, so you can't be forced to talk. But you can be forced, not forced, but a court order, give blood, DNA swabs, hair samples, any of those things. So they will get that from him.
All right. Now, what about the idea that he had been accused before? This thing never went to trial. That's still pending in civil court. Would the knowledge of that be admissible in court if this went to prosecution?
That's what's really interesting. Because again, if it ever gets that far, and we don't know if it will, but if it does, most people would think, well, if I'm a juror, first thing I want to know is, has he done something like this before? And that's sort of common sense, right? One of the things that happens in a courtroom, sometimes counterintuitive, the law says, generally speaking, there's some exceptions, generally speaking, the jurors would not be told about somebody's prior episode. Again, there are exceptions here, but the rule is you're not told that, because we tell jurors, we want you to decide this case on the facts of this case alone. We don't want you to say, because he did it again, chances are he did it this time. So a little counterintuitive, but jurors probably wouldn't hear about that.
Okay, Jack, thanks so much.
Okay,
do appreciate it.